Chapter Internal Aids and External Aids of Interpretation. As an aid is a device that helps or assists for the purpose of construction or interpretation, the court has to take recourse to various internal and external aids. Internal aids to construction, those which are available within the Act itself. Internal aids mean those materials which are available in the statute itself, though they may not be part of enactment. These internal aids include a long title, preamble, headings, marginal notes, illustrations, punctuations, provisos, schedule, transitory provisions, etc. When the internal aids are not adequate, the court has to take recourse to external aids. Now, first, long title. Ashwini Kumar Ghosh versus Aravinda Bose. Petitioner was an advocate in Calcutta High Court as well as Supreme Court. He filed in the registry in the original side a warrant of authority executed in his favour to appear for his client, on the ground that under the High Court rules and orders, original side, an advocate cannot act but only plead. The warrant of authority was returned. He argued that since he is also an advocate of Supreme Court, he had a right to act and plead all by himself without any instruction from an attorney. The Supreme Court looked at the long title of the Supreme Court Advocates Practice in High Courts Act, which said enacted to authorize advocates of Supreme Court to practice as of right in any High Court, and accepted the contention of the petitioner. The leading Irish case in East Donegal Cooperative Marts Limited versus Attorney General, in which the courts stressed the importance of the long title to the Act in forming a part of the context and background of the Act, in the light of which its provisions should be construed. Walsh, the judge, departed from the more restrictive rule in allowing for a determination of ambiguity only after the long title has been considered. He said, the long title and the general scope of the Act constitute the background and the general scope of the context in which it must be examined. The whole or any part of the Act may be referred to and relied upon in seeking to construe any particular part of it, and the construction of any particular phrase requires that it is to be viewed in connection with the whole Act, and not that it should be viewed detached from it. The words of the Act, in particular, the general words, cannot be read in isolation, and their content is to be derived from their context. Therefore, words and phrases which at first sight might appear to be wide and general may be cut down in their construction when examined against the object of the Act, which are to be derived from the study of the Act as a whole, including the long title. Until each part of the Act is examined in relation to the whole, it would not be possible to say that any particular part of the Act was either clear or unambiguous. Preamble. In Keshavananda Bharati versus State of Kerala, Supreme Court held that a preamble is a part of the Constitution. It is in fact a key to the minds of the framers of Constitution. In S.C. Sharma versus Delhi Administration, it was held that the appellant challenged his conviction under Section 5 of the Prevention of Corruption Act on the ground that after the establishment of the Delhi Special Police Establishment, that is CBI, the Anti-Corruption Department of the Delhi Police has ceased to have the power of investigating bribery cases because the preamble of the Delhi Special Police Establishment Act pointed out to this effect. SC rejected the contention and held that no preamble can interfere with the clear and unambiguous words of a statute. Definition or interpretation clause. It is used for extending the natural meaning of some words. In Ardeshir versus State of Bombay, it was held that the appellant was working salt mines without a license. He claimed that a salt mine is not a factory as per Factories Act because it is an open space with no building, and so it does not fall under the definition of a factory, which requires the factory to have a precinct. Supreme Court held that the definition of factory in Section 2M, which says factory means any premises, including the precincts thereof, is an inclusive definition and does not delimit the meaning of the word premises but enlarges its scope. So, salt mine is a factory. Proviso. In T. Devadasan versus Union of India, it was held that the carry forward rule in reservation under which if SC/ST quota was unfilled, it would be carried over, was in question. Due to this rule, the number of reserved posts exceeded 65%, which violated Article 16 Clause 1. Supreme Court held that unlimited reservations under 16 Clause 4 would destroy the spirit of 16 Clause 1. Article 16 Clause 4 is a sort of proviso to 16 Clause 1, and so it could not be interpreted so as to destroy the main provision. In Dwarka Prasad versus Dwarka Das, Supreme Court held that lease of a building along with its equipment for cinema business was not an accommodation within the meaning of UP Temporary Control Rent and Eviction Act. If the principal enactment is a statute is unambiguous, proviso can neither extend nor restrict its meaning. Schedule. Messrs. Asaf Ali Pharmaceuticals versus State of Maharashtra, Supreme Court held that in the case of a clash between the schedule and the main body of the Act, the main body prevails and the schedule has to be rejected. In this case, Supreme Court held that Ashwagandharishta, an Ayurvedic medicinal preparation containing self-generated alcohol but not capable of being consumed as ordinary alcoholic beverage, would be exempt from excise duty. Punctuation. In Muhammad Shabbir versus State of Maharashtra, one of the provisions of Drugs and Cosmetics Act said that whoever manufactures for sales, sells, stocks or exhibits for sale or distribute. Supreme Court held that mere stocking is not an offence unless it is for sale because there is no comma after stocks, and so the words stocks and exhibits both are qualified by sale. External aids to construction. External aids may be parliamentary material, historical background, reports of a committee or a commission, official statement, dictionary meaning, foreign decision, etc. In B. Prabhakar Rao versus State of AP, Supreme Court Judge Chennappa Reddy observed, where internal aids are not forthcoming, we can always have recourse to external aids to discover the object of legislation. External aids are not ruled out. This is now a well-settled principle of modern statutory construction. Dictionary. When a word is not defined in the statute itself, it is permissible to refer to dictionaries to find out the general sense in which that word is understood in common parlance. However, in the selection of one out of the various meanings of a word, regard must always be made to the scheme, context and legislative history. In Ramavtar versus Assistant Sales Tax Commissioner, it was held that the question was whether betel leaves are vegetables and therefore exempt from imposition of sale tax. Dictionary meaning of the term vegetable includes both betel leaves. However, Supreme Court held that the dictionary meaning could not be said to reflect the true intention of the framers, and the word vegetable should be interpreted in the same sense as it is commonly used. Item that is served on the table. Textbook. In Keshavananda Bharati versus State of Kerala, a large number of textbooks were quoted. However, observed that in view of many opinions and counter-opinions, it was not desirable to follow the opinions in the books, and the safest route for the court was to interpret, keeping in mind always the whole context of the issues. Historical background. Next item. In State of West Bengal versus Nripendranath, Supreme Court held courts are free to look into the earlier state of the law to find out the true meaning of the enactment. Next, parliamentary history, historical facts and surrounding circumstances. Historical setting cannot be used as an aid if the words are plain and clear. If the wordings are ambiguous, the historical setting may be considered in order to arrive at the proper construction. Historical setting covers parliamentary history, historical facts, statement of objects and reasons, report of expert committees. Parliamentary history means the process by which an act is enacted. This includes the conception of an idea, drafting of the bill, the debates made, the amendments proposed, etc. Speech made in mover of the bill, amendments considered during the progress of the bill or considered in parliamentary history, whereas the papers placed before the cabinet which took the decision for introduction of the bill are not relevant, since these papers are not placed before the parliament. The historical facts of the statute, that is an external circumstance in which it was enacted, is also should be taken into account, note, so that it can be understood and the statutes in question were intended to alter the law or leave it where it stood. Statement of objective and reasons as to why the statute is being brought to enactment can also be a very helpful fact in the research for historical facts, but the same if done after extensive amendments in statute, it may be unsafe to attach these with the statute in the end. It is better to use the report of a committee before presenting it in front of the legislature, as they guide us with the legislative intent and place their recommendations which come in handy when enactments of the bill. The Supreme Court in a number of cases referred to debates in the Constituent Assembly for interpretation of constitutional provisions. Recently, the Supreme Court in S.R. Chowdhury versus State of Punjab has stated, it is a settled position that debates in Constituent Assembly may be relied upon as an aid to interpret a constitutional provision, because it is the function of the court to find out the intention of the framers of the Constitution. But as far as speeches in Parliament are concerned, a distinction is made between the speeches of the mover of the bill and the speeches of other members. Regarding speeches made by the members of Parliament at the time of consideration of a bill, it has been held that they are not admissible to external aids or extrinsic aids to interpretation of statutory provision. However, speeches made by the mover of the bill or minister may be referred to for the purpose of finding out the object intended to be achieved by the bill. K.S. Paripurnan versus State of Kerala. So far as the statement of objects and reasons accompanying a legislative bill is concerned, it is permissible to refer to it for understanding the background, the antecedent state of affairs, the surrounding circumstances in relation to the statute, and the evil which the statute sought to remedy, but it cannot be used to ascertaining the true meaning and effect of the substantive provisions of the statute. Case Devados, dead and represented by LRs versus Veeramakkali Amman Koil. Reports of commissions include law commission or committees, including parliamentary committees, preceding the introduction of a bill, can also be referred to in the court as evidence of historical facts or of surrounding circumstances or of mischief or evil intended to be remedied. Law commission reports can also be referred to where a particular enactment or amendment is the result of recommendations of law commission report. Supreme Court in Rosie and another versus State of Kerala and others considered the Law Commission of India 41st report for interpretation of section 200 clause 2 of the Code of Criminal Procedure 1898. Legislative history. In A.K. Gopalan versus State of Madras, while disallowing a speech to be considered as an aid to interpretation, observed that a speech made in the course of the debate on a bill could at best be indicative of the subjective intent of the speaker, but it could not reflect an inarticulate mental process lying behind the majority vote which carried the bill. In Keshavananda Bharati versus State of Kerala, it was held that speeches made by members of parliament in course of debates relating to an enactment of a statute cannot be used as aids for interpreting any of the provisions of the statute. However, Justice Shelat, Grover, Reddy, Palekar and Matthew were of the opinion that speeches in the Constituent Assembly could always be used to find out the true intention of the framers of the Constitution. It seems that this opinion is limited to interpretation of the Constitution. In Indira Sani versus Union of India, Supreme Court held that since the word backward classes used in Article 16 Clause 4 is not defined anywhere, it is permissible to refer to the speeches of Dr. B.R. Ambedkar to understand the context, background and objective of the provision. Social, political and economic developments and scientific inventions. A statute must be interpreted to include circumstances or situations which were unknown or did not exist at the time of enactment of the statute. Any relevant changes in the social conditions and technology should be given due weightage. Courts should take into account all these developments while construing statutory provisions. In S.P. Gupta versus Union of India, it was stated the interpretation of every statutory provision must keep pace with the changing concept and values. It must be, to the extent to which its language permits, or rather does not prohibit, suffer adjustments through judicial interpretation so as to accord with the requirement of the fast changing society which is undergoing rapid social and economic transformation. It is elementary that law does not operate in a vacuum. It is therefore intended to serve a social purpose, and it cannot be interpreted without taking into account the social, economic and political setting in which it is intended to operate. It is here that the judge is called upon to perform a creative function. He has to inject flesh and blood in the dry skeleton provided by the legislature, and by a process of dynamic interpretation invest it with a meaning which will harmonize the law with the prevailing concepts and values and makes it an effective instrument for delivery of justice. Therefore, court has to take into account social, political, economic developments and scientific inventions which take place after enactment of a statute for proper construction of its provision. Reference to other statutes. In case where two acts have to be read together, then each part of every act has to be construed as if contained in one composite act. However, if there is some clear discrepancy, then the latter act would modify the earlier. Where a single provision of one act has to be read or added in another, then it has to be real in the sense that in which it was originally construed in the first act. In this way, the whole of the first act can be mentioned or referred to in the second act, even though only a provision of the first one was adopted. In case where an old act has been repealed, it loses its operative force. Nonetheless, such a repealed part may still be taken into account for construing the unrepealed part. For the purpose of interpretation or construction of a statutory provision, courts can refer to or can take help of other statutes. It is also known as statutory aids. The General Clauses Act is an example of a statutory aid. The application of this rule of construction has the merit of avoiding any contradiction between a series of statutes dealing with the same subject. It allows the user of an earlier statute to throw light on the meaning of a phrase used in a later statute in the same context. On the same logic, when the words in an earlier statute have received an authoritative exposition by a superior court, use of same words in similar context in a later statute will give rise to a presumption that the legislature intends that the same interpretation should be followed for construction of those words in the later statute. Judicial decisions. When judicial pronouncements are being taken as reference, it should be taken into note that the decisions referred to are Indian. If they are foreign, it should be ensured that such a foreign country follows the same system of jurisprudence as ours, that is common law based. These decisions have been taken on the ground of the same law as ours. These foreign decisions have persuasive value only and are not binding on Indian courts, and where guidance is available from binding Indian decisions, reference to foreign decisions is of no use. Other materials. Similarly, Supreme Court used information available in the internet for the purpose of interpretation of statutory provision in Ramlal versus State of Rajasthan. Courts also refer passages and materials from textbooks and articles and papers published in journals. These external aids are very useful tools not only for the proper and correct interpretation or construction of statutory provision, but also for understanding the object of the statute, the mischief sought to be remedied by it, circumstances in which it was enacted, and many other relevant matters. In the absence of admissibility of these external aids, sometimes courts may not be in a position to do justice in a case. In Lowinger, Jurymetrics, the methodology of legal inquiry, coined the term jurymetrics to cover the application of communication theory and the use of mathematical logic in law in relation to jurisprudential inquiry. Use of quantitative techniques might enable lawyers to move beyond jurisprudence to a truly scientific investigation of law. Thus, for example, confusion created by semantic ambiguity in a legal discourse might be minimized by the use of symbolic logic in, say, the interpretation of statutes. Next chapter, interpretation of constitution. In interpreting a constitution, it must be borne in mind that it is an organic statute, and therefore that construction which it is most beneficial to the widest amplitude of its power will be adopted. It will not be construed with the strictness of a private contract. That is not to say that different rules of construction apply to the construction of a constitution. If at all there is a difference, it is in the degree of emphasis that is laid upon the rules. The application of the very rules of construction regarding construction of statutes requires that the court should take into account the nature and scope of the law that it is interpreting. To remember that it is a constitution, the mother of all laws, the mechanism under which laws are made, and not a mere act which declares what that law should be. Therefore, in the construction of a constitution, a broad and liberal spirit will be adopted. Nevertheless, this does not apply that the courts are free to stretch or pervert the language of the enactment to the interest of any legal or constitutional theory, even for the purpose of supplying omissions or for correcting supposed errors. Besides, the courts have to guard themselves against extending the meaning of words beyond their reasonable connotation. The case in relevance is Diamond Sugar Mills versus State of UP. Principles and theories. In Jagmohinder Das versus State, Supreme Court has held that not only the general definitions given in General Clauses Act but also the general rules of construction given therein are applicable to the Constitution Act, allows the use of General Clauses Act. The Constitution is an organic instrument. It is the fundamental law. The general rule adopted for constructing a written constitution is the same as for constructing any other status. The Constitution should be interpreted as to give effect to all its parts. There are basically three types of interpretation of the Constitution. One, historical interpretation. Ambiguities and uncertainties while interpreting the constitutional provisions can be clarified by referring to the earlier interpretative decisions. Second, contemporary interpretation. The Constitution must be interpreted in the light of the present scenario. The situation and circumstances prevalent today must be considered. Harmonious construction. The Supreme Court held in Re Kerala Education Bill that in deciding the fundamental rights, the courts must consider the directive principles and adopt the principles of harmonious construction. So, two possibilities are given effect as much possibility by striking a balance. In Qureshi versus State of Bihar, Supreme Court held that while the state should implement the directive principles, it should be done in such a way so as not to violate the fundamental rights. In Shahjahan versus Ms. Kamala Narayan, Supreme Court held that the harmonious interpretation of the legislation is justified if it makes effective use of any other provisions in the same or another enactment. In Bhatia International versus Bulk Trading, it was held that if more than one interpretation is possible for a statute, then the court has to choose the interpretation which depicts the intention of the legislature. General rules of interpretation of the Constitution. 1. If the words are clear and unambiguous, they must be given full effect to. Second, the Constitution must be read as a whole. Third, principles of harmonious construction must be applied. Fourth, the Constitution must be interpreted in a broad and liberal sense. 5. The court has to infer the spirit of Constitution from the language. 6. Internal and external aids may be used for interpreting. 7. The Constitution prevails over other statutes. Preamble as a tool. In Keshavananda Parsi versus State of Kerala, Supreme Court held that the preamble is a part of the Constitution. It is in fact a key to the minds of framers of Constitution. Supreme Court identified the basic structure of the Constitution that reflects its true spirit and held that nothing that hurts the basic structure of Constitution is constitutional. In the same case, Supreme Court held that one should give the freedom to Parliament to enact laws that ensure that the blessings of liberty be shared with all, but within the framework of the Constitution. It is necessary towards the end that the Constitution should not be construed in a narrow and pedantic sense. The preamble cannot override the provisions of Constitution. In re Berubari, the Supreme Court held that the preamble was not a part of Constitution and therefore it could not be regarded as a source of any substantive power. Interpretation of international instruments and presumption against violation of international law. Article 51C of the Constitution of India states that the state shall endeavour to foster respect for international law and treaty obligations in the dealings of organized people with one another. It may be said that the distinction in Article 51C between international law and treaty obligations is that the term international law refers to international customary law. The acceptance of such an approach would mean that the customary international law is not incorporated into Indian municipal law ipso facto. Cross-reference the British and American practice. In league with this approach, in the contention that the Article 51C reduces the position of international law in India to a mere directive principle. Article 372(1) of the Constitution provides that subject to other provisions of the Constitution, all the law in force in the territory of India immediately before commencement of the Constitution shall continue in force therein until altered or repealed or amended by a competent legislature or other competent authority. Thus, if there is any irreconcilable conflict between a pre-constitutional law and a provision of the Constitution, the latter shall prevail to that extent. The expression law in force includes not only the enactment of the Indian legislature, but also the common law of land which was being administered by the courts in India, including the rules of English common law. This leads to the conclusion that the common law doctrine is applicable in India. Therefore, international law is enforceable by Indian courts insofar as it is not inconsistent with any clear and unequivocal or unambiguous Indian statutory law. Rules of international law are not mere ethical rules, although it was otherwise held in ADM Jabalpur versus Shivkant Shukla. The dissenting judgment of Justice Khanna rightly held the view that if two constructions of the municipal law are possible, the court should lean in favour of one, adopting such construction as would make the provisions of the municipal law to be in harmony with international law or a treaty obligation, and that the rule about the construction of a municipal law also holds good when construing the provisions of Constitution, and that a construction of the relevant constitutional provisions was possible as would not bring them in conflict with the Universal Declaration of Human Rights, Article 8 and 9, right to an effective remedy and no arbitrary arrest. The declaration, not in itself legally binding, much of its content can now be said to be form part of customary international law. Justice Khanna's opinion has been followed in Vellore Citizen Welfare Forum versus Union of India by Supreme Court. Next, international treaties. Article 51 of the Constitution embodies the object of India in the international arena as follows. The state shall endeavour to promote international peace and security, maintain just and honourable relations between nations, foster respect for international law and treaty obligations in the dealings with organized people with one another, and encourage settlement of international disputes by arbitration. But it does not lay down that international treaties or agreements entered into by India shall have the force of a municipal law without appropriate legislation. In other words, India's obligations under international treaty cannot be enforced unless such obligations are made part of the law of this country by means of appropriate legislation. It is the power of the executive to enter into treaties, the executive power being coextensive with the legislative power, and there being no legislation on the subject, while Article 73 and 246 Clause 1, read with entry in 14 of the Union List. The executive power is vested in the President, while Article 53, which may be exercised by him through the officers subordinate to him. By virtue of Article 253, Parliament had exclusive power to make any law for implementing any treaty. Article 253 is in conformity with the object declared by Article 51C. Treaty making, implementing of treaties, etc. is the subject of Union legislature under entry 14 of the Union List, but it would have been difficult for the Union to implement its obligations under treaties or other international agreements if it were not able to legislate with respect to state subjects insofar as that may be necessary for the purpose of implementing the treaty obligations of India. Hence, Article 253, by the words notwithstanding anything in the foregoing provisions, empowers the Union Parliament to legislate on matters included in the state list for the said purpose. These words mean that the distribution of legislative powers between the Union and States shall not restrict the power of Parliament to make laws under Article 253. The Diplomatic Relations Vienna Convention Act 1972 was enacted to give effect to Vienna Convention on Diplomatic Relations 1961. The question whether a particular treaty calls for an implementing legislation would depend upon its subject matter. Legislation would be required to give effect to a treaty A where it provides for payment of money to a foreign power. Example, Union of India versus Manmul Jain. B. Where justiciable rights of the citizens or others are restricted or infringed. Example, Maganbhai Ishwarbhai Patel versus Union of India. C. Where laws of the state are modified. Case again, Maganbhai Ishwarbhai Patel versus Union of India. Even an amendment of constitution would not be required where implementation of a treaty would involve cession of Indian territory to a foreign power, but nothing is required where it merely involves the settlement of a boundary dispute not involving cession. Case again, Maganbhai. No cession of territory, no law. The concept of self-executing and non-self-executing treaties is also recognized by Supreme Court in Maganbhai. Legislation may nevertheless be passed in aid of implementation of a self-executing treaty, though not necessary. International treaties vis-a-vis statute law. It is well established in law that in case of conflict between international treaties and clear and unambiguous statute law, courts will give effect to statute law. If the statute law is ambiguous, the courts adopt the doctrine of harmonious construction so as to avoid conflict between international treaties and the statute law. In other words, Indian courts construe ambiguous statute law in the context of international treaties. In Jolly George Varghese versus Bank of Cochin, the Supreme Court harmonized Section 51 of the CPC, power of court to enforce execution, civil imprisonment, with the International Covenant on Civil and Political Rights. Article 11 of the Covenant provides that no one shall be imprisoned merely on the ground of inability to fulfill a contractual obligation. The words "or" has had since the date of the decree the means to pay the amount of the decree. In Section 51, CPC must imply some element of bad faith beyond mere indifference to pay. If the judgment debtor once had the means but now has not, or if he has no money now on which there are other pressing claims, he should not be cast in prison, as the same would be violative of the spirit of Article 11 of the Covenant, also held under violative of Article 21 of the Constitution. Article 9 Clause 5 of the Covenant provides that anyone who has been the victim of unlawful arrest or detention shall have the enforceable right to compensation. In Nilabati Behera versus State of Orissa, Supreme Court invoked the said provision for the purpose of granting compensation in a writ petition for violation of fundamental right under Article 21. This holding was reaffirmed and followed in D.K. Basu versus State of West Bengal and People's Union for Civil Liberties PUCL versus Union of India. In M.V. Elizabeth versus Harwan Investment and Trading, the Supreme Court referred to a certain international covenants on the maritime law and upheld the admiralty jurisdiction of the High Court, AP High Court, over a foreign vessel in an Indian coastal state's waters, holding that the sovereignty of a state extends over its internal and territorial waters. Though a merchant ship is generally governed by the laws of the flag state, it subjects itself to jurisdiction of a foreign state as it enters its own territorial waters. In Vellore Citizen Welfare Forum versus Union of India, Supreme Court held that it is almost accepted proposition of law that the rule of customary international law, which are not contrary to the municipal law, shall be deemed to have been incorporated in the domestic law and shall be followed by the courts of law. Sustainable development as a balancing concept between ecology and development has been accepted as a part of the customary international law, though its salient features have yet to be finalized by the international law. Jurists, precautionary principle and polluter pays principle, two of the salient principles of sustainable development, are now part of the environmental law of the country. In MC Mehta versus Kamalnath, the Supreme Court held that the public trust doctrine too was a part of the law of the land. In Vishaka versus State of Rajasthan, Supreme Court held that the regard must be made to international conventions and norms for construing domestic law when there is no inconsistency between them and there is a void in the domestic law. In the absence of domestic law occupying the field, to formulate effective measures to check the evil of sexual harassment of working women at all workplaces, the contents of the international conventions and norms are significant for the purpose of interpretation of the guarantee of gender equality, right to work with human dignity in Article 14, 15, 19, 1G and 21 of the Constitution, and the safeguards against sexual harassment implicit therein. This is implicit from the Article 51C and the enabling power of the Parliament to enact laws for implementing international conventions and norms by virtue of Article 253, read with entry 14 of the Union List. Under Article 73, the executive power of the Union is available until the Parliament enacts a legislation. Supreme Court invoked the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, Article 11 and 24 in laying down the guidelines on the subject. In Liverpool and London Association Limited versus MVC Success, Supreme Court held that where no statutory law in India operates in the field, interpretative changes, if any, must be made having regard to the ever-changing global scenario. In Pratap Singh versus State of Jharkhand, the Supreme Court observed that the courts can refer to and follow international treaties, covenants and conventions to which India is a party, although they may not be part of our municipal law. A contextual meaning to a statute is required to be assigned, having regard not only to the Constitution but also international law operating in the field. The court held that the Juvenile Justice Care and Protection of Children Act 2000 should be interpreted in the light of the Universal Declaration of Human Rights as well as the United Nations Standard Minimum Rules for Administration of Juvenile Justice 1985 Beijing Rules. In Entertainment Network India Limited versus Super Cassette Industries, Supreme Court observed that the court has in number of cases applied the norms of international law, in particular the international covenants, to interpret the domestic legislation if by reason thereof the tenor of domestic law is not breached, and in case of any inconsistency the domestic legislation should prevail, and further noted that in interpreting the domestic municipal laws the court has extensively made use of international law inter alia for the following purposes: as a means of interpretation, 2. Justification or fortification of a stance taken, 3. To fulfill spirit of international obligation which India has entered into when they are not in conflict with the existing domestic law, 4. To reflect international changes and reflect the wider civilization, 5. To provide a relief contained in a covenant but not in a national law, 6. To fill gaps in law. The Supreme Court also observed that the courts should not be loath to refer to some international conventions where the protection of human rights, environment, ecology and other second generation, third generation rights are involved. In Keshavananda Bharati versus State of Kerala, S.M. Sikri, then Chief Justice of India, had observed that in view of Article 51 of the Directive Principles, the court must interpret language of the Constitution, if not intractable, which is after all a municipal law, in the light of the United Nations Charter and solemn declaration subscribed to by India. He relied on the observation of Lord Deming in Corocraft versus Pan American Airways that it is the duty of these courts to construe our legislation so as to be in conformity with the international law and not in conflict with it. Next heading: Reading Directive Principles and Fundamental Duties with Fundamental Rights. The Supreme Court held in Re-Kerala Education Bill that in deciding the fundamental rights, the court must consider the directive principles and adopt the principle of harmonious construction. So two possibilities are given effect to as much as possible by striking a balance. In Qureshi versus State of Bihar, Supreme Court held that while the state should implement the directive principles, it should be done in such a way so as not to violate the fundamental rights. Next heading: Presumption on favor of constitutionality of a statute. Words in a constitutional enactment conferring legislative powers would be construed by the courts most liberally and in their widest amplitude. G.R.G. Rao, Cotton Mills versus State of MP. The omnipotence of the sovereign legislative power will not be limited by judicial interpretation, except so far as the express words of the Constitution give that authority. But in order to decide whether a particular legislation offends the provisions of the Constitution and is therefore unconstitutional, the court will try to examine with some strictness the substance of the legislation by determining what it is that the legislature has really done. Where in the interpretation of the provisions of the Act two constructions are possible, one which leads towards constitutionality of the legislation would be preferred to that which has the effect of destroying it. Case is Atmaram versus State of Bihar. Where two constructions are possible, the court will adopt that which will ensure the smooth and harmonious working of the Constitution and eschew the other which will lead to absurdity or give rise to practical inconvenience or makes well established provisions of existing law nugatory. Case Chandramohan versus State of UP. Presumption against ouster of jurisdiction of courts. The ordinary right of recourse to the courts for trial of any claim is one of the rights which is not to be curtailed except by clear words. So far as the jurisdiction of the High Court and Supreme Court in respect of the issue of writs under Constitution is concerned, it cannot be taken away by the form of words. In general, presumption is that ordinary courts of law, namely the civil courts, criminal courts, high courts and Supreme Court, have jurisdiction over people. Any statute which takes away the jurisdiction of ordinary courts must be rarely resorted to, as people have the right to have the free access to all the courts. Jurisdiction of civil courts. The basic presumption of law is that all civil courts are empowered to decide all suits of civil nature. The basis of the presumption is that civil and criminal courts have general jurisdiction over people and have right to have the free access to both civil and criminal court. Section 9 of CPC. It was emphasized by Supreme Court that the rule prescribed by Section 9 of CPC is that the court shall subject to provisions contained in the code, have jurisdiction to try all suits of civil nature except the suits in which their cognizance is either expressly or impliedly barred. The law further presumes that a remedy in that ordinary civil court must always be available to citizens. Legal provisions excluding jurisdiction of civil courts and conferring jurisdiction to tribunals must strictly be interpreted in such a way that as far as possible the jurisdiction of civil courts are not taken away. If the statute contains two interpretations, then the one that conferring jurisdiction will prevail. Exclusion of jurisdiction must be expressed or clearly implied. Not possible to curtail jurisdiction of High Court and Supreme Court except by an amendment to the relevant provisions in the Constitution. That is, normal law can bar all subordinate courts. Only a constitutional amendment can bar High Court and Supreme Court jurisdiction. Jurisdiction of other courts. The general presumption is that a statute should not be given such an interpretation as to take away the jurisdiction of the court unless the language of the statute is unambiguous and clear. Since jurisdiction has been given to court by legislation, it is the legislation alone which can take away the jurisdiction. If any statute provides for the express bar of jurisdiction of a civil or other court, then the scheme of the particular act must provide adequate alternative remedies. If the constitutionality of any provision is to be challenged, the writ of certiorari is the only recourse. There is no sympathy for legislative provisions which oust the jurisdiction of courts because of the fact that the subjects are deprived of a remedy. If jurisdiction is conferred to a tribunal, the intention of the Parliament is presumed to have jurisdiction to correct the decision of inferior tribunal. Finality clause. Many modern statutes contain provisions which attempt to take away the jurisdiction of courts by making the decision of the tribunal final and conclusive. The remedy by certiorari is never to be taken away by any statute except by most explicit and clear words. The word final means without an appeal. It does not mean without recourse to the writ of certiorari. It makes the decision final on fact but not on law. In Dhulabai versus State of MP, Supreme Court held that if a statute gives finality to the old orders of special tribunal, the jurisdiction of the civil court must be held to exclude only if there is an adequate alternate remedy similar to what civil remedy will be. In R versus Medical Appeal Tribunal, Lord Deming said the word final only means without appeal, and the remedy of certiorari cannot be taken away because it is not an appeal. Creating new and enlarging existing jurisdictions, it is presumed that a statute does not create a new jurisdiction or enlarge existing jurisdiction. Express language is required if an act is to be so interpreted as to create a new jurisdiction or enlarge existing jurisdiction. In Health Star Properties Limited, a statute giving power to grant relief on being satisfied on certain facts does not confer on it any power to grant interim relief until such fact had been fully ascertained. In State of UP versus Muhammad Nu, in a departmental inquiry against the constable, the person holding the trial offered to be a witness and prosecuted the constable. There was a gross violation of the principle of natural justice. The court held that it can issue a certiorari writ. Presumption against retrospective operation of law. Legislatures have legislative power to legislate retrospectively or to make the entire statute or some provisions to operate prospectively. However, penal statutes cannot create offences retrospectively. In view of the prohibition contained in Article 20, Clause 1 of the Constitution of India, it is well recognized rule that a statute should be interpreted, if possible, so as to respect vested rights, where the effect would be to alter a transaction already entered into, where it would be to make that valid which was previously invalid, to make an instrument which had no effect at all, and from which the party was at liberty to depart as long as he pleased, binding. The prima facie construction of the Act is that it is not to be retrospective. There is a presumption against retrospective effect being given to a statute. When no contrary intention is shown, the courts assume that the statute deals with the future and not with the past. No statute will be construed to have retrospective operation unless such a construction appears very clearly in terms of the Act or arises by necessary implication. Cases P. Janardhan versus Union of India. Statutes creating substantive rights or liabilities which are not procedural operate prospectively unless express words are used giving them retrospective effect. When procedural laws are made or amended, they are retrospective in nature and they affect all pending actions in courts or tribunals. One must be very careful and make specific provisions in the transitory provisions stating clearly which provisions of the Act or amending statute apply only prospectively. A long list can be found in Section 97 of the CPC Amendment 1976, whereby only prospectively is given several procedural provisions of the amending Act. Giving retrospectively to substantive provisions in some cases may offend Article 14 of the Constitution or be quite unfair on the face of it. Efforts should be made to see that undue hardship is not caused. Then we have declaratory statutes or provisions which are always retrospective in their operation. Perpetual and temporary statutes and rules. A statute is either perpetual or temporary. It is perpetual when no time is fixed for its duration, and a statute remains in force until it is repealed either expressly or by implication. A temporary statute is one which is enacted to be in force for a specified period, unless it is repealed before that period. Finance Acts which are passed annually are not temporary, and they are often contain provisions of a general character which are of a permanent operation. The duration of temporary statute can be extended by fresh amendment or exercising the power delegated to the government to extend in life. When a temporary act expires, another is reenacted. The normal rule is that under Section 24 of General Clauses Act, any appointment, notification, order, scheme, rule, form, bylaw issued under the Act would, unless expressly provided otherwise, shall be deemed to have been made or issued under the provisions so reenacted of the new Act. Validation of a statutory provision declared as ultra vires and giving retrospective effect to it. By far one of the most difficult aspects of drafting concerns validating laws which have been declared ultra vires or validating them retrospectively. If a statute has been struck down by a court as being defective in certain respects and therefore unconstitutional, the legislature can remove the defect and give retrospectivity to a statutory removal of the defect and thus make the statute valid with retrospective effect. The statute can then validate the provisions which has been struck down. It can give retrospective effect to the validation. Of course, it is obvious that where a statute is struck down on the ground of lack of legislative competence as not being within the scope of the subjects listed in the relevant list of 7th schedule of the Constitution, there is no scope for validating such a law. Care must be taken while removing the defect retrospectively that the judicial decision as such is not overruled by the legislation, for that would be ultra vires of the principle of separation of powers between legislature and the judiciary, and as each has its own respective jurisdiction and powers. While a statute cannot be drafted in a manner just to override a judgment, it can however rectify the defect pointed out by the court and remove the defect with retrospective effect. The validating section that uses the words notwithstanding any judgment, decree or order of the court, and if this is properly done, it is permissible in law to validate the provisions which is struck down by the court, and this will not amount to encroaching into the field earmarked for the judiciary under the doctrine of separation of powers. By careless drafting, the legislature has sometimes failed either wholly or partly in trying to achieve the validation of a statute. Such cases are many. See Janapada Sabha Chindwara versus Central Provinces Syndicate, D. Kawasji Company versus State of Mysore, State of Haryana versus Kamal Cooperative Farming Society, Government of AP versus GVK Girls High School. It is rather surprising that in spite of earlier judgments pointing out the manner in which a validating law could be passed retrospectively, mistakes have been committed as recently as in year 2000. Curative legislations have to be carefully drafted. If a certain area was not validly included in a municipality, a validating act which merely declares it to be included would be ineffective unless such area is to be deemed to have been always previously included. Case Delhi Cloth General Mills Company Limited versus, that is DCM, versus State of Rajasthan. The same principle is applied in construing the machinery sections of a taxing statute so as to make that machinery workable. CIT versus Mahalram Ramjidas and Guru Sahai versus CIT. Next chapter, legislative drafting. Principles and process of legislative drafting. Legislative drafting is done by the legislative department of the government, and it is legislation that controls and regulates the conduct of citizens. The constitutional provisions deal with human rights, and it distributes legislative, executive and judicial power to various institutions and describes their function, rights and duties and powers and privileges. Legislature promulgates laws and they can be preceded by ordinances issued by the legislature or heads of states, and these ordinances and replaced by statutes. Laws must be within the scope of legislative powers of the particular legislature, be it federal or state. The laws must not be violative of the human rights provisions or other provisions of a written constitution. A written constitution is not necessary if the legislation is to be made, and that was and is the position of the United Kingdom even today. The only change in that country in recent times has been that there have now a Human Rights Act 2000, which came into force on 2nd October 2000. Legislation can also be made by monarchs. Whatever be the nature of the political structure of a country, legislation is necessary to contain executive action, and legislative draftsmen are necessary and have to develop the skills of drafting. The draftsman is not the author of the legislative policy, he merely tries to transform the legislative policy into words. The legislative policy is made by the political executive, which belongs to the political party which is ruling the legislature, or by the monarch who reigns over the country. The draftsman must therefore digest the legislative policy fully before he produces the instrument of legislation which can achieve the legislative purpose. This is different from the interpretation of legislation. The process by which a judge, or indeed any person, lawyer or layman who has the occasion to search for meaning of a statute, construes from the words of a statute book a meaning which he either believes to be that of the legislature or which he proposes to attribute to it, is called interpretation, and as per Salmon. Words in any language are not scientific symbols having any precise or definite meaning, and language is but an imperfect medium to convey one's thought, and much less of a large assembly consisting of persons of various shades of opinion. It is impossible even for the most imaginative legislature to forestall exhaustively all the situations and circumstances that may emerge after enacting a statute where its application is called for. A statute as enacted cannot be explained by the individual opinion of the legislators, nor even by a resolution of the entire legislature. After enacting process is over, the legislature becomes functus officio so far as the particular statute is concerned, so that it cannot itself interpret it. It can, however, amend the statute by introducing explanations as to the meaning of words in the legislation previously enacted. Legislative definitions may deviate from the reality or dictionary meaning so much that a building may include an open platform having no wall or roof, and a brick kiln may be excluded from the meaning of that word. It is impossible to define when the maintenance of a machine ends and repair starts, and where repair of a house ends and reconstruction begins. Lord Cransworth said, "There is no possibility of mistaking midnight for noon, but at what precise moment twilight becomes darkness is hard to determine. No draftsman can envisage all the circumstances which may possibly arise in the course of human conduct. From time to time, therefore, events occur which are either within the plain words of the statute or are yet outside its evident purpose, or vice versa. This is the battleground on which are fought the battles between the literal constructionists and the purposive constructionists." Lord Dew Park stated that there is inevitable interaction between the methods of parliamentary drafting and the principles of judicial interpretation. Statutes like the taxation laws are quite complex and run into the very many clauses, provisos, explanations, exemptions that it makes it very extremely difficult for anybody to understand the meaning of the words, much less legislative intention. Thomas Jefferson, one of the founding fathers of the American Constitution, said of such laws as follows: "Statutes, from their verbosity, their endless tautologies, their involution of case within case, and the parenthesis within parenthesis, and their multiplied efforts at certainty, by saids and aforesaids, by ors and ands, to make them more plain, are really rendered more perplexed and incomprehensible, not only to common readers but also to the lawyers themselves." In his Decline and Fall of the Roman Empire, Gibbon has described the attitude of the Locrians to the legal system. If a member of that community proposed an amendment in the existing law, he had to stand forth in the assembly with a noose around his neck. If the law was rejected, the innovator was instantly strangled to death. In Goodhart said, "There was, as we must all recognize today, considerable sense in that procedure. The rule that a law expresses the intention of the legislature applied to the good old leisurely days, where laws were few and the legislator had the time to scrutinize the laws carefully before passing them. The draftsman of today is supposed to prepare the maximum of laws within a minimum of time, to express the intention of some anonymous mythical person whose identity is not easily established, and to express the intention in language so clear that not only a reasonable man understands but a malicious one cannot misunderstand. It is essential," writes Montesquieu, "that only such words should be used by the lawgiver as are bound to produce the same notions in the minds of all men." Courts have often been severely criticized of draftsmen, so we must have jurisprudence, interpretation of statute, and drafting of laws together in one course. Courts have often been severely critical of draftsmen, says one judge. The statute is so confused that it could not have been more confused if confusion had expressly been aimed at. Lord Macmillan said about one section of trademarks that it was couched in language of fuliginous obscurity. Lord Justice Scruton, in a judgment on the Rent Restriction Act, regretted that he could not order the costs of a case before him to be paid by the draftsmen of the Act and the members of the legislature who passed the Act. Yet occasionally one comes across a judge who understands the difficulties of a draftsman. There can be no better defense of a draftsman than the following classic passage from a judgment of Denning. The English language is not an instrument of mathematical precision. Our literature would be much poorer if it were. This is where the draftsmen of the Acts of Parliament have often been unfairly criticized. It would certainly save the judges trouble if Acts of Parliament were drafted with a divine prescience and perfect clarity. In the absence of it, when a defect appears, a judge cannot simply fold his hands and blame the draftsman. He must get to work on the constructive task of finding the intention of the Parliament. And he must do this not only from the language of the statute, but also from the consideration of the social condition which gives rise to it, and of the mischief which it was passed to remedy. And then he must supplement the written word so as to give force and life to the intention of the legislature. A judge should ask himself the question, if the makers of the act had themselves come across this rock and the texture of it, how would they have straightened it out? He must then do so as they would have done. A judge must not alter the material of which it is woven, but he can and should iron out the creases. The Denning lay expressed in this judgment were condemned by Lord Simons in Magor vs. St. Mellons. Simplicity, preciseness, consistency, alignment with existing law. Before actually drafting a bill, it is always advisable to prepare a rough scheme of the bill. If the bill is to be divided into chapters, the heading of each chapter and the subject matter of each of the clauses which is to go into each chapter should be noted. At this stage, it is not necessary to draft the clauses. What is necessary is to note down the subject matter of each clause. The proposed marginal heading of a clause will generally give sufficient indication of the subject matter of a clause. Care should be taken that the clauses are in a logical sequence and follow the usual pattern of a bill. The work of a draftsman is akin to that of an architect. What I have described as a rough scheme should form the plan which should be followed in raising the final structure. A draftsman should use simple language. An American girl said of the 10 Commandments that they confuse your mind because they tell you what not to do, but do not tell you what you ought to do. I wonder what the gracious girl would have thought of the bewildering mass of modern laws. It is puerile to contend the laws could be so drafted that everyone can understand them. How can a law relating to patents be drafted so that everyone understands it? There is a story of a judge who was hearing a patent case. An authority was cited to him. The judge inquired, is that a book of a recognized authority in this branch of the law? Counsel replied in the affirmative. Well, the judge said, I doubt it. Whether the passage you read from it could be part of the law of patents because it sounds like common sense. But laws, even on technical subjects like patents, could be so drafted that they are intelligible to those who have some knowledge of the subject. Each clause of the bill should contain one idea only. If an idea is complicated, it should be expressed in a series of subclauses. A subclause should not normally contain more than one sentence. Each clause of the bill should be drafted to a separate sheet so that there is ample space for making corrections. A draftsman should bear in mind the maxim laid down by the great parliamentary counsel Lord Thering, that the same thing should invariably be said in the same words. A draftsman should provide for all contingencies which are likely to arise. He should have what is called as divine prescience. Failure on the part of the draftsman to foresee certain contingencies have sometimes led the courts to adopt strange interpretations. Generally, several drafts are prepared. All these drafts should be preserved. They indicate the working of the mind of the draftsman and are useful when any question arises why a particular provision has been put in a particular form in the final draft. No paper, including any paper containing rough notes connected with the drafting of a bill, should be destroyed. Such papers, which may appear to be useless at the time of drafting, sometimes prove to be very valuable later on when a draft bill is subjected to close scrutiny in the legislature or elsewhere. They will actually show what is discarded so that you know what is included. There should be an interval of a few days between the preparation of the first draft and its revision. If a draft bill is revised immediately, the mind of the draftsman is likely to move in the same groove, with the result that he may not notice any mistake. But if the draft bill is revised after an interval of a few days or a month, the draftsman will be able to bring a fresh mind to bear upon the draft and will thus be in a better position to detect any mistakes. The necessity of revising a draft bill cannot be sufficiently emphasized. As has been said, what appear to be tired to the tired eye in the watches of the night to be without blemish may be full of errors and inconsistencies under the cold light of the morning. Time permitting, a draft bill should be given as many readings as possible, and it will be found that with each reading new mistakes are discovered. If a draft bill is referred to a select committee, the draftsman before attending meetings of the select committee should go through all relevant papers to refresh his mind, since a long interval usually elapses between the preparation of a bill and its discussion in a select committee. He should not rely upon his memory. He should study all the opinions given in connection with the draft bill and give the draft bill itself a thorough reading. His grasp over the draft bill will be so thorough that he should be able to explain all the points that may be raised in the select committee. A draftsman should not place himself in the predicament which confronted Browning, who asked what his poem Sordello meant, replied, "When I wrote Sordello, God and I knew what it meant. Now only God knows what it means." Next chapter. Drafting, General Laws, Special Laws, Rules and Orders. The following are the general principles of interpretation which a drafter has to bear in mind. According to Ilbert, regard should be had to the general rules for interpretation of statutes as laid down in the ordinary textbooks. Among the most important of these are a rule that an act must be read as a whole. Therefore, the language of one section may affect the construction of another. The rule that an act may be interpreted by reference to other acts dealing with the same or a similar subject matter. The meaning attached to a particular expression in one act, either by definition or by judicial decision, may be attached to it in another, and the variation of the language may be construed as indicating change of intention. The general rule that special provisions will control the general provisions. Next, the similar rule that where particular words were followed by general words, horse, cow and other animal, the generality of the latter will be limited by reference to the former, ejusdem generis rule. The general rule, subject to important exceptions, that a guilty mind is an essential element in a breach of a criminal or a penal law. It should therefore be considered whether the words willfully and knowingly should be inserted, and whether, if not inserted, they would be implied unless expressly negated. The presumption that the legislature does not intend any alteration in the rules or principles of the common law beyond what it expressly declares. The presumption against an intention to oust or limit the jurisdiction of the superior courts. The presumption that an act of parliament will not have extraterritorial application. The presumption against any intention to contravene the rules of international law. The rule that the Crown is not bound by enactment unless specially named. The presumption against the retrospective operation of a statute, subject to an exception so as to enactments which affect only the practice and procedure of the courts. The rule that a power conferred on a public authority may be construed as a duty imposed on that authority. May is equal to shall. Next heading, overview of interpretation of statutes. The following extract from the Oxford Dictionary of Law summarizes the subject. Interpretation of statutes is the judicial process of determining, in accordance with certain rules and presumptions, the true meaning of the act made by the Parliament. The principal rule of statutory interpretation are as follows. 1. An act must be construed as a whole so that internal inconsistencies are avoided. 2. Words that are reasonably capable of only one meaning must be given that meaning whatever that result. This is called the literal rule. 3. Ordinary words must be given their ordinary meanings and technical words their technical meanings, unless absurdity would result. This is the golden rule. When an act aims at curing a defect in the law, any ambiguity is to be resolved in such a way as to favor that aim, the mischief rule. 3. The ejusdem generis rule of the same kind. When a list of special items belonging to the same class is followed by general words, as in cats, dogs and other animals, the general words are to be treated as confined to other items of the same class. In this example, other domesticated animals. Next, the rule expressio unius est exclusio alterius. The inclusion of one is the exclusion of the other. When a list of specific items is not followed by general words, it is to be taken as exhaustive. For example, weekends and public holidays excludes ordinary weekdays. Ambiguities may occasionally be resolved by referring to the external sources. For example, the intention of Parliament in regard to a proposed act as revealed by the ministers during their passage through the Parliament. There are some general presumptions relating to interpretation of statutes. They are presumed: 1. Not to bind the crown, including the sovereign personality. 2. Not to operate retrospectively as far as substantive but not procedural law is concerned. Next, not to interfere with the vested rights, particularly without compensation. Next, not to oust the jurisdiction of the courts. And 5. Not to derogate them from constitutional rights or international law and international rights. But clear words or necessary implication may override their presumptions. A consolidating statute is presumed not to be intended to alter the law, but this does not apply to codifying statutes, which may be concerned with clarifying law that was previously unclear. Penal and taxing statutes are subject to strict construction. That is, after applying normal rules of interpretation, it is still doubtful whether or not a penalty or a tax attaches to a particular person or a transaction. The ambiguity must be resolved in favor of the subject. That is the book completed on